There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello and good day, everyday Americans. This is Paul Engel with the Constitution Study. We are here to read and study our Constitution, to teach the rising generation to be free, to return the Constitution to its rightful owners, we, the people of the United States of America. I am glad you could join me today. Have kind of a follow-up topic, a little follow-up episode. First, I want to point you to the website, constitutionstudy.com. There you can find out all things Constitution study. You can see where we're going. You can see where I'll be speaking. You can read articles, find episodes of the podcast, just lots of interesting things, and lots of other organizations that we are working with to help you, again, read and study your Constitution. Last week, we talked about the Incorporation Doctrine. And, well, let's just say it's the gift that keeps on giving. Those of you who know me personally know I follow primarily auto racing. I love top tier auto racing. And there's a time in auto racing, and in fact, in a lot of different sports, they refer to as the silly season. The time of year when there are rumors all over the place about what's going to happen next, who's going to be traded, who's going to be let go, what's going to happen for next year. And I've come to consider pretty much any time the Supreme Court is in session is my silly season. That's the time of year when all sorts of weird stuff is going to come out, because it seems like every time I've heard the silliest thing, the silliest arguments come out, the silliest opinions of the court, they prove beyond a shadow of doubt. No matter how silly you are, how silly proof you make something, they'll always make it sillier. And today we're going to deal with some silliness around both the Incorporation Doctrine and civil asset forfeiture. So if you want to find out more, again, the website, I've got an article I wrote on this, but I want to talk to you about it here because I'm seeing a lot of discussions. I've had a recent online tete-a-tete with a gentleman discussing, among other things, the Incorporation Doctrine. And by the way, I enjoy, well, they can't always say enjoy it. Sometimes it's frustrating, but it's good. It's good to take time to examine what we believe and why we believe it, and prove again to ourselves that we're right. And when we find that we're wrong, to make a modification. That's what we're here for, to find out what it actually says and modify our position accordingly. Now, today comes with a court case. You may have heard there were arguments. This is, I think it was mid-December, in a case called Timbs v. Indiana, docket number 17-1091. The way I understand it, Mr. Timbs was arrested in Indiana on multiple drug charges. He eventually pled guilty to one charge of felony dealing and one charge of conspiracy to commit theft. In exchange, the state dismissed the remaining charges against him. Now, after accepting the plea, the trial court sentenced Mr. Timbs to 6 years, 5 of which were suspended. Timbs was also agreed to pay fees and court costs totaling about $1,200. The state, however, also sought the forfeiture of Mr. Timbs' Land Rover under the civil asset forfeiture law. If you're not familiar with civil asset forfeiture, I have articles about it up on the website, but the court denied the state's request, noting that the maximum fine the law allowed Mr. Timbs was $10,000, while this relatively new vehicle in question was purchased for approximately $42,000. So I'm even accounting for depreciation. It was worth well in excess, multiple times the $10,000 maximum fine. The court said such a forfeiture was grossly disproportional to the seriousness of the offense. And eventually the case came before the Indiana Supreme Court, who overturned both the trial judge and the Court of Appeals decision. They did so because, quote, the United States Supreme Court has never enforced the excessive fines clause against the states, and we opt not to do so here. The framers' original conception was settled long ago that the Bill of Rights applies only to the national government and cannot be enforced against the states. To date, the Supreme Court has incorporated most of the first 8 amendments with a few notable exceptions. That, by the way, close quote, comes directly from the Supreme Court of the state of Indiana in the case versus Tyson Timbs. So let's start at the beginning. First of all, the Supreme Court of the United States does not enforce law. That's not their job. They do not have the power. It is the executive branch that enforces law. It is the court's job, their role, their sole power, the judicial power, to look at the facts and the law in the case before them and making a decision that's appropriate and just. So the fact that the Supreme Court hasn't, quote unquote, enforced it is legal hogwash. It's this idea. If you listen to last week's episode, we talk about Barron, where the Supreme Court said, hey, listen, the Bill of Rights doesn't apply to the states. We can't find any place in the Constitution that says that the Bill of Rights applies to the states, when quite plainly Article 6 says, every judge is, supreme. The Constitution is the supreme law of the land, and every judge in every state is bound to it's the term they use, regardless of state law or state constitution. So we have a legal fiction that continues. Second, and that gets to the second point, the idea that the Bill of Rights was meant to apply only to the federal government and not the states. Again, it's fiction. It is an opinion of a court that is in direct contradiction to the actual words of the Constitution of the United States, which they have sworn to uphold. The Constitution under the Supremacy Clause. Now, Mr. Timbs appealed to the Supreme Court of the United States asking if the 8th Amendment applied to the states, and oral arguments were heard on November 28th. Mr. Hotat, I believe that's how it's pronounced, the attorney for Mr. Timbs, not only stated the salient point, but showed the silliness of today's legal education. Quote, the freedom from excessive fines applied to the states the freedom from excessive fines applies to the states because it is deeply rooted in our nation's history and traditions and fundamental to our scheme of ordered liberty. Close quote. This idea of what selective incorporation, the theory that the first 10 amendments to the Constitution apply only to the federal government, not the states, it's just wrong. I mean, it's Mr. Justice Gorsuch tried to get that whole idea off the table. It was actually interesting to read. He asked Mr. Fisher, the Indiana Solicitor General, quote, General, before we get to the REM argument and its application to this case, can we just get one thing off the table? We all agree that the excessive fines clause is incorporated against the states. Whether this particular fine qualifies because it is in REM forfeiture, another question. But can we at least get the theoretical question off the table? Whether you want to do it through the due process clause and look at history and tradition, excessive fines guarantees against them going back to the Magna Carta and 1225, the English Bill of Rights, the Virginia Declaration of Rights, pretty deep history. And whether one wants to look at privileges and immunities, you might come to the same conclusion. Can we at least agree on that? Close quote. Now, Mr. Fisher apparently did not agree. His response was, quote, well, I think with respect to an in personam, the answer is yes, but you have to take into account, and this is the methodology of McDonald, you have to take into account the history and traditions of the right being claimed, close quote. Later, we see this exchange. Quote, Justice Gorsuch said, quote, well, whatever the excessive fine clause guarantees, we can argue again about its scope and in rem and in personam, but whatever it in fact is, it applies against the states, right? Mr. Fisher. Well, again, that depends. Mr. Gorsuch. I mean, most of these incorporation cases took place in the 1940s, and here we are in 2018 still litigating incorporation of the Bill of Rights. Really? Come on, General. Close quote. Now, you may be asking yourself, what's so silly about this case and the exchange between the lawyers and the justices? See, apparently, while the trial in Indiana appeals court justices can read the U.S. Constitution, no one in the Supreme Court, no one in the court that day could actually read the Constitution. The supposedly brightest legal minds in the country could not find Article 6, Clause 2, which says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." Now, I don't know about you. I don't know how much clearer it needs to be. The Eighth Amendment is part of the U.S. Constitution. Therefore, it is the supreme law of the land. The Eighth Amendment does not include any language that targets it specifically at the federal government. And it says, quote, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted," close quote. That's all it says. The idea of the supremacy clause has been ignored in jurisprudence, as I said, for almost 200 years. Apparently, the justices on the Supreme Court don't feel they're bound to the Constitution, even though the judges in Indiana appear to, at least at the trial and appeals level. See, this is the part that drives me crazy. We can disagree on a lot of things, but when we start changing or ignoring the actual words on paper, when they don't mean what they clearly say, then we have a problem. See, I would laugh at the lengths that lawyers and justices go to find a loophole to get what they want if it wasn't so tragic that they cannot read the answer that should be right under their noses. See, I go back to Mr. Timbs' lawyer, and it's quite clear, and even Mr. Gorsuch. Yes, the Eighth Amendment is part of the Constitution. Yes, the Supremacy Clause says all judges, including the state judges, are bound to it. Why do we have to go back to, well, it's tradition, and gee, isn't it important, and go back to the Magna Carta? It's there in black and white. How can you claim you uphold the law when you ignore the supreme law of the land? How can we laud these legal minds when the simplest of answers eludes them? Worst of all, how can we bow to such foolish judgments? See, sadly, until we figure out how to read and apply the Constitution for ourselves, we will be ruled by this lawless and arrogant board of constitutional illiterates. And as much as I love getting involved in these things, I do get a little tired of making the same point over and over and over again, only to be countered with opinion. You see, I'm not talking about making everything a federal case. I'm not even talking about how the justices should decide in this particular case. My point is, why is a simple concept that the Constitution is the supreme law of the land and judges in every state are required to be bound to it. Why is that not brought up in what is obviously a case about, does the Constitution matter or not? So we can go into the rest of it, and this is part of the discussion that I've been having. We can go into the rest of, well, what does it mean and how do we apply it? But if we can't agree that the Constitution means what it says on paper, can we agree on anything? And if we can't hold our elected officials accountable to support the Constitution, to oversee the other branches of government like they're supposed to, and hold them accountable to what the Constitution actually says, does the Constitution matter anymore? And if the constitutional protection against excessive fines doesn't matter, what about the taking of property and due process and protections from unreasonable search and seizure and the right to a trial by jury and to be aided by counsel and the right to confront your accuser and to compel witnesses in your favor. You see, once we start ignoring certain rights because they're inconvenient or they don't match up with our worldview or our opinion, then it all starts falling apart, because now the Constitution becomes malleable. It becomes what men and women in black robes say rather than what the words on paper say. And that to me is an extremely dangerous situation, extremely dangerous point. So I hope you found this interesting. Hope it makes you think. What does it mean that the Constitution is the supreme law of the land? What does it mean when the smartest legal minds in our nation can't find the supremacy clause in the Constitution? What does it mean when the words of prior judges take precedence over the law? It means, in my opinion, a country ruled by men, not by laws, a very dangerous situation to be in, and one I hope our education will help fix. Not for us, but for our children, for our grandchildren, for the generations that will follow, that will either laud us for the stand that we take or curse us for the liberties that we've lost. So, everyday Americans, men and women out there, please read and study the Constitution for yourself. If you want more assistance, again, head over to constitutionstudy.com. There are links to find groups where you can study it with local people. There are resources to help you read and study. There are places where you can ask questions and get them answered. The point is we read. The point is we need to educate ourselves if we are going to regain control of our nation, if we are going to continue to be the land of the free and the home of the brave. So head out into this week, head out and enjoy yourself. Spend a little time with the family, read, study, ask questions. And I hope to see you next time on the Constitution Study.
Every day